So I want to welcome everybody to tonight's event at Your Expert Nation. And it is, of course, on Can I Write That While They're Still Alive? And the events we have in Your Expert Nation's conference room every other month are always selected to be things of interest to people in the writing profession and people who want to learn more about publishing. And so we selected this topic simply because so many people have asked us questions related to it. And I could not be prouder to be able to bring you these three people to address the questions and give you the answers that we all have. So first we're going to introduce ourselves, and then I warn the people in the room, I'm going to ask you to introduce yourselves. I'm Bridget Marmion, and have spent several decades in publishing, over a decade each at Farrar, Straus Giroux, Random House, and Houghton Mifflin, mostly as Director of Sales and Marketing, or mostly as Senior VP of Marketing, to be honest. And then about 4 years ago, launched my own marketing firm, Your Expert Nation. And I'm proud and excited that today we work with authors published by houses large and small, everybody from Random House to Pushcart Press, and in fact, a growing number of authors who are self-published. And now I'm going to ask my distinguished guests to introduce themselves, because I wouldn't even try to condense their incredible biographies into 1 or 2 lines. So, ELINOR LIPMAN.
Yes, hello, welcome. I'm mostly a novelist. I've published, my 11th novel's coming out in a year, but I started writing essays, mostly for Boston Globe column, where I was one of rotating for something called a coupling column, and I represented the long married. So when we're answering questions, I'll get into what that was like. And then in the last presidential election, I had this idea to write a rhyming political tweet. I had this idea 15 months before the election to write a rhyming political tweet every freaking day until the election, which turned out to be 15 months before, and that turned out to be Tweetland of Liberty, which is irreverent rhymes from the political circus. So that was fun. And so I write, the essays happily got collected into a book called I Can't Complain. And I here, I think, represent personal essays really about people I know, people not only I know, people I'm related to, people I love, people I live with. So there's that delicacy and decision-making and negotiation. So it's not exactly walking a tightrope, but it's the balance beam. So that's...
And Boris Kachka.
Hi, Boris Kachka. I cover publishing and writers and also some other forms of culture and entertainment. This is my, this was my most time-consuming work. There's a history of Farrar, Straus Giroux, for which I interviewed Bridget and a couple of other of you here. It's a history of a publishing house that goes back and covers the living and the dead, which I guess was one of my qualifications for being here. I also have done a number of profiles of writers, especially writers who are now in their 70s or 80s, and who, some of whom did not want to be written about, which I think it would be very interesting to talk about and get into, and dealing with the question of, whether we are better off writing biographies of people when they're still alive, or is it better after they've passed on, legally, ethically, and in terms of the stuff you get. Yeah, looking forward to that.
Yes.
For New York Magazine is mainly where I write about these things.
And Jen, Constantine.
Well, I'm the general counsel of the Authors Guild, and I've worked there for 10 years. And the Authors Guild is the nation's largest professional organization for writers and the leading writers advocate for fair compensation, effective copyright protection, and free expression. This is my commercial. That's the end of my commercial. I've been in publishing for many years on both sides of the aisle. I'm an author's advocate. and I am rabid in terms of representing authors. But in 14 years before that, I worked for News Corporation, and HarperCollins reported into me, and at that point I was a publisher's advocate. And prior to that, I worked at the old Macmillan since 1982. So I've been on the publisher side, I've been on the author side, but I have two family members who are writers. So I've been on the side where I've been written about too. So I am sensitive to the situation where people, my husband's books, Lloyd Constantine, were both nonfiction, and they were about, one was about a lawsuit and the other was about his time with Eliot Spitzer at the governor's mansion. And my son writes an autobiographical fiction novel about his youth. So we'll talk about that later. But it's hard being the subject of a family member's book. And so I can talk on both sides of everything. That's what lawyers do. They turn on a dime. When you represent somebody, that somebody is your focal point, and you do everything you can for that somebody. But the next day, you're representing somebody else. So you have to be really flexible and ready to change directions. And I've managed to do that in my many years of practice.
So Jan today will give us the rules of the road, if you will, and along the way probably a couple of inconvenient truths, but things that we should be aware of. So now I'm going to very quickly go around the room and ask each of you simply to say your name and your role in publishing. Are you an agent, a writer, a publisher? Just so all of us know, our audience. And then I'm going to very quickly say who I know is listening outside the conference room here. So Rakia.
Hi, my name is Rakia Clark. I'm a senior editor at Beacon Press.
Laura Ross, and I'm an independent editor and ghostwriter and that kind of thing, having spent many years in publishing on the editorial and marketing side.
My name is Dagmar Grimm, and I'm a translator, a writer, and a project editor.
I'm Esther Margolis, I'm a publisher and now literary agent and consultant and publisher, possibly yet again. But anyway, Newmarket Press is my company.
Anne-Marie.
I'm Anne-Marie Cunningham. I've met some of you before. I'm a writer.
And formerly with NPR as a science writer.
I was with Science Friday, which was a big vehicle for selling books. And I'm an Authors Guild member.
Thank you.
And Mary.
I'm an Authors Guild member.
I love
My
this.
name's Mary Evans. I'm a literary agent at Mary Evans Inc. And my first job in publishing was at Farrar Straus in the contracts department. So I've had quite an arc to where I am now.
I'm Patricia Mulcahy, and it's really nice to see a lot of people here I haven't seen in ages, such as Mary. I also started at Farrar Straus and talked to Boris briefly, because I was Mr. Giroux' secretary. That was my first job. I was in publishing for many years. My last job was editor-in-chief at Doubleday, and I'm now an independent writer and editorial consultant. And I was really interested tonight because I haven't thought about this issue since I worked at Viking, and we were sued because of a novel that was published, and a woman in it felt she had been portrayed to be a hooker. It was one of those situations where...
And that was our agency's client. I can tell you the deep inside story.
Okay. But we had a seminar with Martin Garbus, the famed First
Oh,
Amendment
yes.
attorney.
He's a good friend.
And the whole issue of how you have to disguise a real person to put them in a novel and avoid litigation was fascinating, and I haven't thought about it in ages, so I thought I would come tonight.
That novel was called State of Grace.
Exactly.
And our next guest.
I'm Ivana Folle, I'm from Italy. I'm a director of the Boris Study Center, where I met for the first time Elinor, that now is one of my best friends. Yes.
Well,
Arrived
welcome.
today from Genoa. So,
Welcome.
And I'm Rich Kelly. I also worked with Mary Evans and Bridget Marmion at Farrar, Straus Giroux back in the day. I am currently Vice President and Strategic Partner at Your Expert Nation, where I focus on online marketing and content development.
And before I introduce our audience from remote, Eric, would you mention the name of your company helping with the live streaming today?
Yeah, so we're Kinetic. We're a live streaming health and fitness platform. So we're providing a live stream for your expert nation this evening.
And we were connected by my son, Dan Fogarty, who's also in media and publishing. He works for Boston.com, and that's how I got to meet Eric. Because publishing really is only 17 people. We pretend it's bigger, but it really is only 17 people.
All worked at Farrar, Straus.
Apparently.
Yeah.
Apparently.
Yeah.
So now I'd like to acknowledge our audience who's participating outside the conference room here at Union Square. Jennifer McGuire, a publicist. Barbara Clark, an agent who worked at Farrar, Straus Giroux. Melissa Nasson, who's with Beacon Press.
Hi, Melissa.
Contracts director of Beacon Press, as I understand it.
Beacon Press published this
Yes,
book.
I didn't want to interrupt, but
Yeah.
on
Okay.
cue, Rocky walked in as you were holding up her
little
book.
plug. Okay.
And Kathleen Crumpton, who is a self-published author, as well as Amy Brown, another author, I believe a YA middle grade writer, and Sarah Ragg. So, I want to let everybody know about the format of today's event. My wonderful guests decided that it would not be a panel per se, but more like a conversation. So, we will begin with an introduction to the ground rules and a bit of a statement by Jen, and then it's going to be a conversation. But they make it sound casual, and meanwhile, Boris and Eleanor have given a lot of thought to the adventures they've had while writing their books or their columns, and they're going to share them with you incredibly candidly. I do want to let you know that we'll be having this conversation until about 7:10, and then we're going to open the floor to questions and answers. And right now, could we put up the slide, please? So I want to let our remote attendees know the email address to send any concerns about being able to hear us clearly or see us. And also that is where you'll send questions and answers anywhere along the evening, but we'll be addressing those at around 7:10 after we've had our conversation. We also, of course, have a hashtag, and we invite everybody here to live tweet. It's hashtag Can I Write That? So we'd be grateful for anybody to share the conversation outside the group attending tonight. So right now, I'm going to ask Jan if she'd like to start by telling us a little bit of the most important truths we should know.
I would love to. And first, thank you, Bridget, and everyone, Rich, for inviting me to come. And I am honored to be on a panel with two esteemed authors. Today's topic, excuse me, is can I write that while they're still alive? The assumption here being that you can say anything you want about a deceased person, but to quote George Gershwin, it ain't necessarily so, as you'll see later on in my talk. But I digress. So in order to give you and our panelists context for this panel, I'd like to begin by quoting from an expert in the field of defamation, Mr. Donald Trump. Last Friday, in a Texas stump speech, Mr. Trump lambasted the media, focusing on news organizations, asserting that, quote, one of the things I'm going to do if I win is to open up our libel laws so when they, and I assume he meant reporters, journalists, and authors like you here, write purposefully negative and horrible and false articles, we, and I assume he means himself, can sue them and win lots of money. Now, Trump continued, yeah, well, he always sues for $5 million. Yeah. We're going to open up those libel laws so when the New York Times or the Washington Post writes a hit piece, which is a total disgrace, we can sue them and win money instead of having no chance of winning because they're totally protected.
Just because it's true that it's not going to enter into it, right?
Well, I've personally had two experiences with him. One, when he sued the New York Post, where I represented when I was at News Corporation, because we underrepresented his net worth. And he felt that ruined his reputation, and he did sue for $5 million. And the second, I was involved as just a consultant with a friend from Hachette, where Donald Trump, there was an unauthorized biography of him, and same exact cause of action. He didn't feel that his net worth was high enough, and he sued, and he lost both times. And I'm going to explain why he cannot achieve his objective. The answer to his attempts to change the libel law is a resounding no way. So let me explain a little bit about libel and the First Amendment. Before 1964, the Supreme Court took the position that civil libel lawsuits were purely a state matter, that the federal government was not going to get involved. In a case called the New York Times versus Sullivan, the court established that there were constitutional limits to what the states can do in awarding libel judgments. And after Sullivan, public figures, including politicians and other famous or infamous people like Mr. Trump, can win a defamation lawsuit against a media organization only, and I emphasize only, if he or she can prove that the publication published with actual malice. This is a legal term, and it means with knowledge that the statement was false or was made with reckless disregard of whether it was false or not. And that language comes from the Supreme Court of the United States. Among other things, the Supreme Court found that the media needs some breathing space in their handling of controversial issues, including when errors inevitably occur during, quote, robust debate of these issues. And because public officials voluntarily move into the public arena, subjecting themselves to more scrutiny, criticism comes with the territory. And this is what the court decided in making this decision. Since Sullivan, the media has to be guilty of something beyond mere publishing a falsehood. There has to be some level of fault. A series of cases after the Sullivan case broadened the definition of public figures, resulting in the current law in all states, 50 states, where public figures, including politicians, have to prove actual malice, while private persons need prove only some level of negligence. And each state has its own law which says what it has to prove. In New York, it's gross negligence. So Donald Trump is correct in one respect. It is indeed hard to win a defamation lawsuit if you're a public figure, since actual malice is very difficult to prove. But he is wrong about a president's ability to single-handedly open up or change libel law jurisprudence. And I refer you to a New York Times article, front page, which is entitled, this was on Monday, "Past Court Duels Influence Obama." And essentially, the article says Obama's only won in the Supreme Court during the 7 years he's been there with his Solicitor General 47% of the time. And even though he can appoint judges and has appointed some, there's no guarantee that they're going to decide in his favor. So even should Donald Trump win and pack the court, there's no guarantee that he's going to change New York Times versus Sullivan and any of the other cases that came afterwards. So at least we don't have to worry about that. There is a system of checks and balances, and any of you who've taken civics know this. And it's the Supreme Court ultimately has the power to change and to form the libel law. And while the president can nominate justices, he or she can't control court's decisions. But most important, defamation is primarily governed by state law and not federal law. So let me just briefly talk a little bit about state law and what defamation is. It's a tort, and what a tort is a civil wrong that creates a right for a victim to sue the perpetrator, as
Can
we
you
say.
talk about what defamation actually is versus libel? And
No, I'm
versus-
about to do that. I
Oh,
want to
thank you.
start with the tort so you
Thank
know
you.
it's a
Okay.
wrong. And media torts are defamation, invasion of privacy, unfair competition, and then there are damages that flow from all of those. Now, defamation is a general statement about damage to a person's reputation and which deserves redress, and every state provides a civil remedy for this. Libel is written. There's a larger audience, it's longer lasting, it's more likely to cause harm because it's in writing. Slander is not written. Broadcast is considered slander in California, but in other cases, because it is in a broadcast medium, it's considered libel. So again, it's state law, so you have to go to the state. Plaintiffs must prove special damages in order to win a case, unless there are one of four categories. First, if the plaintiff is accused of a serious crime involving moral turpitude. Then if they say, you know, he's a thief or a prostitute or something like that, they don't have to prove special damages. The second is if there's an existing, and excuse the expression, loathsome disease, like if you say somebody has leprosy, and in some states it used to be if you said somebody had AIDS, but the law now is a little better than that. But in some states, I'm sure it's still true. The third is an attack on the competency or honesty in a business context. So if you call somebody a liar and a cheat and a fraud, if you call, you know, if you say a lawyer has committed malpractice, again, they don't have to show special damages. And the fourth is the lack of chastity in a woman. So so the definition of libel or slander, defamation, is the publication of a false statement of fact about a person or entity that is damaging and tends to injure the person's reputation, and which was published with some degree of fault, depending on what the state law is. So publication. In certain instances, if you publish something, fair report privilege comes to play. And that is, if you publish something that happened in the context of a courtroom, media, authors, journalists will not be considered to have violated somebody's rights, because it's fair reportage and they've just reported accurately what's happened. But if you report somebody else's libelous statement or defamatory statement, just because you're republishing doesn't mean you get off the hook. You could still be liable for publishing something that somebody else says. If it's in the courtroom, that's a different story. Also, if it's on the Hill and there's a debate, they essentially have privilege. They can basically say anything they want to in the context of a debate on the Hill. A statement of fact, it can't be an opinion. It has to be objectively verified as true or false. And it has to be of and concerning the injured party. So if you say, you know, all members of the Russian aristocracy are thieves, that is not of and concerning a person. It is too broad. But if you say all the judges who work out of 60 Center Street on the second floor are crooks and they accept bribes, that's getting close, because there may be 3 or 4 of them and you're accusing a smaller group of doing something that would affect their reputation. So, and then it has to be false. So truth is a defense. And unauthorized biographies or unflattering portraits are okay if they don't include false and defamatory statements. If a matter is of public concern or about a public figure, then the plaintiff bears the burden of proof that it's false. If it's a private matter and a non-public figure, some states require a defendant to prove the statement was true or substantially true. In England, they have a whole different burden of proof. And it's much harder there because the defendant has to prove that it's true. Here, the plaintiff has to prove that it's false. You have to prove that there's been damage to your reputation, except for those 4 categories. And again, the media has a little leeway here because it's very important that the First Amendment and the Fourth Estate be protected. Invasion of privacy and the right of publicity is a different tort, but it's still within this family. And privacy it's a much younger cause of action, and it's essentially the right to be left alone. It's protected by evolving areas of tort law in every state. It's not mentioned in the Constitution, but since a case in 1960 called Mapp versus Ohio, it's been rediscovered by the Supreme Court as a constitutional right. And they defined it in that case as the right to be free from unwanted and unnecessary publicity or interference that could injure one's personal feelings or present a person in a false light. So there are 4 types of privacy cases, and in privacy, the courts balance the right of freedom of expression against the right of individuals to be left alone. And they protect people against these 4 types of injury. First, appropriation of a person's name or likeness for advertising or commercial uses. So if somebody uses your photo in advertising salt, and Morton Salt was the first case in this. Somebody's picture was used without permission to put on the box of Morton Salt. They sued, and they said that that was a violation of this individual's right of privacy. The second is disclosure to the public of embarrassing private facts. So, if you read some of the magazines and you say that somebody is, pregnant with somebody else's child and it's totally not true, you're opening yourself up, if there is injury, to some kind of civil liability. The third is placing a person in a false light before the public. And that is essentially saying something wrong against them that can be proven to be incorrect and damaging their reputation. And the fourth is intrusion into a person's seclusion or private life. Sometimes this will manifest itself. I remember a case I had with the New York Post. Princess Diana was in a gym, and she was exercising. And somebody used his influence to get into the gym and take pictures, and they were on the front page of the New York Post. And this person didn't have the right to be in the gym. The person wasn't a member of the gym. And it was, they don't sue the royal family, but it was generally thought to be an intrusion on her expectation to be in a gym without the paparazzi being there. In New York, they only recognize the right of publicity. In California, they recognize all 4. So really, it depends on where you are. The problem with magazine articles and books is, hopefully, you sell in all sorts of jurisdictions. And the person who is complaining that he or she is wronged will live in a certain part of the country. So they can sue where they live, but they can also sue where the book is sold. So that's a jurisdiction issue. Just a couple of more things. To avoid claims, you have to be aware of your contracts. There are indemnification clauses in the agreements, and you publishers know that. You are held responsible for somebody who comes and sues you. That doesn't mean they're going to be correct and they're going to win, but people can sue. It's a free country, even if there's no cause of action. So more often than not, you really have to be aware that you may or may not want to get some kind of media liability insurance for the situations where your contract says you're responsible for half or 20% of your deductible. And in this day and age, the deductibles can be six figures. Wow. So another commercial, we have that insurance, and our members get a discount for that insurance. And it's really to sleep at night. My husband's 2 books, I bought it for him, so I could sleep at night. You need to be able to cite sources for statements, keep copies of documents you use. If sources are confidential, you've got to indicate it. These are all things I told my journalists when I represented the Post. And the last thing I want to say is, when you are sued, it's hell. So you really want to avoid that as much as possible. And I'm going to give you the example of Janet Malcolm. I don't know if you remember this case, but it was a 1991 case involving New York Magazine. And a psychoanalyst and Freud archivist, Jeffrey Mason, sued freelancer Janet Malcolm and New York Magazine for publishing a lengthy article about him containing at least 6 quoted statements that he denied making altogether. Malcolm conducted 40 hours of taped interviews, and some were not taped, and she took notes. He disputed the claim, saying she took no notes during the non-recorded interviews, and she couldn't find her notes at the time during the case. She quoted him, just to give you a sense of it, as an intellectual gigolo, the greatest analyst who ever lived. Lower court dismissed the libel suit, and the Supreme Court, which was the next court up, reinstated the case. Actually, this was the Supreme Court of the United States, I think. Journalists who make minor changes in quoted statements are protected by actual malice. But if the meaning is knowingly or recklessly changed in a material way, and the change hurts the person's reputation, then that person may have a case. There was a jury trial. The jury ruled against Mason, and there was an appellate court, and they upheld it. But the moral of the story is, she did find her notebooks with the quotes, but it was after the jury trial, and her legal fees exceeded $2.5 million. And these were her fees, not New York Magazine's fees. So in a case that you wouldn't have thought was particularly significant, because she didn't, I don't know why he was so sensitive about intellectual gigolo and the greatest analyst who ever lived, it still cost her a pretty penny. So I'm going to turn it over to Bridget and our author friends to talk about their personal experiences, and then we can talk about how to avoid a Janet Malcolm situation in your own work.
What a good idea. So Eleanor, I wonder, what are some of the concerns and some suggested solutions, if you have them, when you're writing an essay about your own life and family?
I take, I don't know if it's the high road or the low road, but I always, in my personal essays, if it's about someone or my relationship with that person, I give it to them to read. And I found that oftentimes, I learned this, that there's kind of the flattery aspect that people are kind of thrilled to be written about. And when I was first asked by the Boston Globe if I would like to be one of the rotating columnists for the coupling, they said, so we're thinking, we know you have a college-age son, maybe you'd want to write about when he brought women home. I said, no way, forget that. And then, no, if that's what no. And then, well, we want you to, you represent the long married. So I said, okay, I can do that. And I told my husband, and he said, well, that's fine, as long as you don't write about me. I wrote about nothing but him. And every column, it would come out, would come out every 5th Sunday, and he'd go to work, and they would say, read that, loved it, so fun. So he couldn't wait for the next one. So part of that is, that's not terribly helpful, except to say that there's that unexpected flattery component, or that, I think there's the break of it being considered
But also,
funny.
the point is that you gave them advance warning. You let them know in advance. That's something key, too.
Yes, I did. But often I did a column that was for the Boston Globe again, for something called Connections. And I had a cousin, actually a second cousin, who was in the French Resistance and jumped off a train that was heading for Buchenwald. And he died only a year ago at 93. And I was writing this with the permission of his children and gave it to them. And I had taken documents and eulogies and given them to my godchild, who for 6 cents a word translated all of these for me. And when I wrote it, this history I had to be so careful about, sensitive. There was one thing they asked me about. The son wanted the name of his school. He was very proud he'd gone to the École Polytechnique. He wanted that in the first paragraph. So I negotiated and didn't. So I find it's sort of permission read it, but then negotiation into get what you want. And, you know, I think it's so easily done. The goal is the most readable, entertaining, from me, you know, entertaining column. And, you know, I have other examples, which I won't say in this moment, but other examples of negotiation that I got my way.
Did you ever have any incident where you were in trouble or somebody didn't?
Oh, I did. It was a short story in my short story collection, and I wrote this about a woman. She was the most obsequious woman I'd ever met. She apologized for if you met her at the market and asked how she was, she'd send you a thank you note. So I think that was my opening line. But I'd never had anything published. I wrote it for a writing group. And then it got published in Yankee Magazine. She didn't see it. And then it got put into a Yankee Magazine anthology. She didn't see it. And then when it came into Viking did a short story collection, she saw it, being a friend, she bought it. Furious, wrote me a letter, sent me a bill. Like I was her consultant. She was my consultant. And that ended that friendship. And as a result of that, in fiction, I made the pledge to myself to I remember even if I'm borrowing someone's, like my friend Felice's red suede suit that she wore to her son's bar mitzvah, and I put it on a character, I said, is it okay if I put that red suit on my character? So, but I have more to say about the fiction, but I don't want to monopolize here.
Yeah. This whole talk is making me nervous all over again, just thinking about what that was. I do have to say that one sort of almost accidental saving grace of the process of writing the book was that, you know, I'll say that, you know, I wrote an article about why is there not enough fact-checking in book publishing, and you know, the answer is that there is some, but the writers pay for it. And I did not pay for a separate fact checker on this book, and I talked to my editor about this in the process of reporting the story, and I said, well, you know, we didn't fact check. He said, of course you fact checked it. Everybody saw early copies. You know, as you recall, we got all kinds of phone calls, and it's true, you know, something that at first I was uncomfortable about, which was that if you write a book about a publishing house, everybody will see it months before you know, you've even fixed all the typos, and because of that, I was able to have those negotiations early. You know, long before we sent out advanced media copies. Now, as far as some of those negotiations, I would say that I have a much easier job than Eleanor because I don't need to be friends with these people. I need it to be true. I need them to, you know, certainly not sue me. But you know, I have to find the truth, and the truth will make nobody completely happy. But you know, as far as what happened when some people did see the early copies, you know, one thing that I sort of learned the hard way was you don't want anyone to be completely surprised by any sort of representation. This was the case with a couple of people who left FSG, whether they were fired or they quit, or, I mean, sometimes that was the thing that was at issue. And so, but because they saw it early, we got to talk about it, and everybody's point of view was represented, and the truth was sort of arrived at a little bit more accurately than it probably would have if they hadn't seen it. The one, you know, I don't know how much to say about this, and I'm sure that some of you will read between the lines, but I did get a legal letter in one case, and it was probably related to that chastity clause that you were talking about. But the way that was resolved, you know, it never came to the point of arguing who's a public figure or what exactly privacy means, but basically it turned out that the main point at issue was a word that I used to characterize this relationship between someone who was alive and someone who was not alive. And once that word was removed, you know, basically it was about preserving someone's dignity. It was not about whether something was true or not true necessarily, but whether you're going to represent people with accuracy but also with kindness. And I found that resolved the issue in that particular case.
Could I talk about another legal point, which is important, and it's a First Amendment point, and it's a prior restraint. So in the situation that you're talking about, if somebody sees a book that's already published, as opposed to the manuscript so that you have a chance to change it. So let's say that happened and they were taking issue with it. They would not be able to restrain the publication of that book. The book is out there, no judge is going to pull a book, and it's really part of our First Amendment. But it doesn't insulate you from the ramifications if you end up in a libel lawsuit. So the book will be out there, but the lawsuit will not be dismissed out of hand. There'll be, somebody will have his or her day in court. So in the situation where you have a manuscript or a story and that you're giving a lot of people the opportunity to give their input, that would probably relieve the probability that you're going to get sued. Most publishing houses, and you guys who work for them, will tell you that they will not give books to people to read and check beforehand. And most publishers like New York Magazine will not either. So these are things that you're doing because of your particular situation.
You know, I remember Esther's question, that the follow-up to that is when the lawyers for Viking Law Department vetted the stories, I said, you know, I better not put that one in because it's based on at least the character of a real person. And they said, no. That is the most universal character in the whole book. Everyone knows someone like this who sends you unnecessary thank you notes. And, well, of course, I got into trouble with her. And there was another story based on my very unhappy experience working for 3 months at WGBH TV in Boston, and that I had to change to a made-up radio station. So cleverly disguised. Yes. So.
But I do think that it's interesting to make this point that, first of all, the situation is different when you're writing in a book as opposed to writing in a column or a newspaper, and letting people know in advance is a good thing. But number one, you're never going to know what is of interest and importance to them. Of everything Eleanor was concerned about, it wound up being the college, the school that the gentleman went to, when everything else was so detailed. So that is one thing.
And I've had 2 modern love columns, and one of them was about the aforementioned husband's decline and death from a rare, it's called frontotemporal dementia. And I know I couldn't have written that as a private, sort of my own privacy when he was still alive, not that he could really read that, but I was very worried about my mother-in-law, surviving mother-in-law. Yet again, she lived in a senior community. They saw it. She just loved having her piece in there. And it was, so, you know, that's not particularly helpful to say, oh, people like love to read about themselves, but yeah. But the other modern love was about a recent one about like my new life and significant other. And it was all, it was very personal about how we met, and then the time off, the interregnum, and and it was, very personal, and I gave it to him to read. And it talked about, sort of the email fight we'd had that led to what he calls he's British, the interregnum. And so what did he ask me to change or add? That as a result of the friendship, I had made new friends through him. So, I mean, the most benign little nothing. And I think it's just that my point is that sometimes it's so not big picture. It's just, I don't know if that's at all helpful, but.
Well, I think it's important to know what literally what the rules are, and then how do you smooth things over so you can write what you want to write, but avoid landmines.
Yeah.
Whether it's a relationship landmine or whether it's a more serious one. And the threat of a lawsuit, as Jan said very clearly, can always be, no matter whether or not ultimately it gets put into. I'd love to turn the conversation now into the conversation about whether you should write a biography on somebody who's an uncooperative living subject, and love Boris to talk a little bit about that.
Right.
Because it sounds like we're waving everybody away from any subject.
Well, but before that, can I just, so Jan, would you say that that was a mistake, letting early copies get out? Does that actually open the publisher up to prior
No,
mistake?
I wouldn't say that. I
Okay.
think it actually protected you, because then if people had a gripe,
Yeah.
they could tell you. But if you were forced to change something that you didn't want to change because it was out there and they were pressuring your publisher and your publisher backed down,
Right.
that would be bad.
Right.
And I would be your advocate on that.
But I don't think you suspected you
No.
had that element
No.
of concern.
Right, and I should say that I was talking to a lawyer at my publishing house, and we had already gotten this letter, so it was part of the conversation.
Right.
Can you tell us what the word is that you took out?
Mistress.
Oh, mistress. Mistress.
Mistress.
Well, that's a very telling word.
Yeah.
Yeah.
You know, it means different things to different people.
Right.
And
My first case when I was a publishing lawyer was involving, remember they used to have those interns where teenagers would come into, I forget which magazine it was a teen magazine, I don't remember, and they won a short story contest, and then they would come in and they'd work for the summer.
Glamour, I think. Oh, Mademoiselle, sorry.
Right.
That's right.
Sylvia Plath.
Yeah, exactly. Somebody wrote about a fictional story about her high school friends, and she called one of them a slut. Names were changed, descriptions changed, and this friend sued in Illinois, and the Illinois highest court held that the word slut was libelous, and she won. And that was a story totally, it was fictional, but based on the characters that she had grown up with. She used her name, so they knew that they were within her high school circle. And now I don't think if she had sued in New York, that would have been the same result. But you never know. And the word slut, I mean, I remember when Saturday Night Live, they had a routine where they said, Shayna, you slut. And Jane, you ignorant slut. Yes, that's right. And nobody thought anything about that. It was pretty funny. But this was not funny because we ended up losing that lawsuit.
Can you just ask a current question having to do with Mr. Trump and the remarks that he has been making that, based on everything you've said, would certainly qualify for some people to sue or to do some kind of action against.
But remember, he's a public figure, and the people he's bashing, for the most part, are his politician competitors. And so nobody in the public arena is going to be able to win that lawsuit for the reasons that I said.
Well, Rosie O'Donnell, he mentioned by name, as someone who he was saying those particular words against.
Well, somebody like that might sue him, and she has the wherewithal to fund a lawsuit like that. Yeah. But he says things which I suppose you could say his opinion that she's whatever she is, as opposed to she, factually is. Yeah.
But
I mean,
it surprises me when people, in the example you gave, when people whose names were changed and maybe some details and whatever come forward to say that's me and I resent that, because they're the one that's pointing out that it's them. I mean, the first thing that happens, and I have a friend who was sued royally over a memoir that he wrote and had changed all of the names, but they came forward and said that's us and what you said isn't true, and then everyone went, oh, we didn't know it was you. Wow, you did those things, So it can be.
well, that could go to the damages, because frankly, if there wasn't any damage before that person said, hey, that's me,
right.
then you could win a lawsuit and get $1 damages, and it'll cost you a lot more than that in legal fees.
You know what Anne Lamott said about how you'll never get sued by an ex-boyfriend if you're doing a fictional character. Give them a really small penis.
Yes, they'll never come forward.
Yeah.
That's very practical. And actually, before we proceed, I want to mention that I did fail to acknowledge two of our other attendees remotely. That's Amy Brown, who's an author, and Sarah Rag. Oh, I did?
Yeah.
Oh, I'm not remembering. I'm glad somebody's listening to me, because I'm not. But Boris, you went to
Yeah, did you want to?
No,
I
please.
didn't mean to ignore your question.
No.
Yeah. I'm like a politician in a debate.
Yeah.
About biographies now, I'm agnostic about whether a full-length biography unauthorized should be written about someone living or not. I think that's fine. I've never had the chance to do it myself, although I did, I did write a piece about Joan Didion with her participation. And then I got asked by an editor, do you think it would be a good idea to write a book? And I thought about it, and I knew that I wouldn't get authorization for that. And I said, well, I just don't think that it would be all that great. And, because I'd read other biographies of living figures like Susan Sontag, I probably shouldn't, start trashing books left and right. I mean, I thought Tracy Doherty's biography of Didion was very good, but a lot of it was about what we don't know about her. It was sort of dancing around that. And I would love to read the book that comes out after her death and everything that opens up, in the wake of that. I think the things that I felt freer to write about people who are no longer living in the book, and which mainly came through, some of the people closest to them, friends, relatives, whose trust I worked to gain, was very valuable, and I probably couldn't have gotten it. I mean, I don't think Roger Straus would have let me read his oral history, but his son did. And I think there's something about the passage of time, the feeling that, well, he's not around to have his feelings hurt. As obviously, it has legal implications, but it has ethical implications, which is why that's the law. But also, I think it makes the book more interesting, potentially, to write about someone who isn't alive. As far as articles, I think that's different because you're just telling a little piece of the story. You're not telling an entire story. So I don't want to go on and on.
But I would like to ask you a slightly different question, but it's an important one. Because in your role, you very frequently have to interview and write about people who don't want to be written about, which is yet a different question. So how do you deal with that?
The most extreme example of that, I think, was when I wrote about Thomas Pynchon.
Yeah, he's a good example, I suspect.
He definitely did not want to be written about. I checked in. He definitely didn't. That was something that people had tried to do before, had done before. I felt like I was on safe ground doing that. He's certainly a public figure. Once I started down that road, though, I realized that there were people who were dedicating their entire lives to finding out every address he had ever lived in, where he lived at the time. I got access to through some mutual friends, to his son's Facebook page. There was all sorts of information that I knew. I drove past his country house, but we didn't publish that information. And I don't know if he would have had grounds to sue if we had.
Well, that could have been an invasion of privacy under certain state laws.
Right.
Because if he's a very private person, it could have opened it up to paparazzi or some kind of...
But he's a public figure, but he chooses
even
to be
so,
a very private person.
But invasion of privacy is a different standard. So in certain states, that could have been actionable. Just to give you another example, Robert Maxwell, you probably know him. He used to sue authors who wrote unauthorized biographies. Tom Bauer was sued 5 times by him because he wanted to, we call it the chilling effect. If you know you're going to get sued by a Trump who can afford to sue you, or a Robert Maxwell who can afford to sue you, then eventually people are going to say, I'm not going to sue. I don't want $2.5 million to defend a suit, even though I'm going to win at the back end. So there are people who are going to use that and their power and their money to try to get you or your publisher to back off.
And that's why it's so important for us to have this conversation, because, as Boris said in an early conversation, it's such a slippery slope not to write about people who don't want to be written about. And those adjustments, by leaving out the address, by leaving out the information that would have perhaps risked that, but still getting the story and doing this incredible article, which I posted up there actually because I enjoyed it so much, which was still revealing about Thomas Pynchon. And this is from somebody who's read an awful lot about him. That's the role of a journalist. But it's a tough road, because our job as publishers is to bring new knowledge, whether or not they want to be written about, but what are the rules, When can they bar you, and when can you still talk about it? That's why I wanted to do this tonight, because it's not a yes or no, it's good judgment. And it's also something else you said earlier that really I like tremendously. There is a question of compassion that comes into it. It's judgment, it's law, it's compassion, it's common sense.
Well, we didn't leave out where his son went to school because we thought we'd get sued over it. And I didn't leave out his address because I thought that was a lawsuit waiting
It's
to
the right
happen.
thing to do.
You know, he wants to be someone who's reclusive. I would assume that their main concern is for their physical person and their family to have some space to operate. Now, if somebody writes a story that other people read about, I doubt he even reads stories about himself. I didn't feel like that I was injuring him personally doing that, at least with what we published.
And is it different when you're writing about the dead? When you're deciding whether or not to put details in about the dead? You kind of referred to it a moment ago, with the loosening of the tongues about people when they're dead, which is...
Yes. Yeah, definitely.
It's different, yeah. They can't sue, they can't feel bad. They're
Also, you
children.
said you got more information probably from somebody
Yes.
after. They're less likely to hold back.
Well, your article
It's
about
probably a
Harper
better
Lee is a
book.
good one to refer
I
to.
think we had a question.
I'm sorry.
Yes, at what point does a person become a public figure? I mean, I'm surprised that Thomas Pynchon is considered a public figure because he's so not in the public eye.
No, but as an author and a renowned author and the winner of prizes, he's by virtue of that, he's a public figure. Yeah, it's not that he's chosen to be a public figure. Remember Richard Jewell, who was one of the suspects in the Atlantic?
Yes.
I was involved in a lawsuit with him. We were saying because of the fact that he was thrown into the limelight, even though it wasn't voluntarily, he was a public figure. And therefore, the New York Post that was being sued by Richard Jewell should be held to the higher standard, actual malice, as opposed to, you know, their responsibility.
I see.
So and there is a lot of litigation which defines who's a public figure. And believe me, that you'd be surprised. Like a public high school wrestling coach was deemed to be a public figure because in that area where he lived, everybody knew him. And a priest, you know, could be considered a public figure in a diocese. But politicians are definitely public figures, and prominent authors, and even mid-list authors who have a following could be considered public figures. Criminals are definitely public figures because they have most likely been on, you know, wanted posters, and they've also been in the newspaper, and people follow the trials. I mean, not every misdemeanor, you know, perpetrator falls within that category, but there's a list of public figures that half of them you probably wouldn't even expect to be on there. And authors are definitely public figures for purposes of libel.
And what about the use of material that, like for example, if you would come across Roger's unpublished journals in some other way and hadn't gotten permission from the family to use them, even though he's no longer alive, could you basically use and quote from those journals?
No, this is the copyright law, and the copyright law says those journals belong to him or his heirs, and therefore, just because you physically own the journals, you still have to get permission
But they're
for.
not published, though. They haven't
Doesn't
been
matter.
published. Doesn't matter.
Doesn't matter.
What about fair use?
Well,
Oh,
if you
boy.
publish the entire
Totally different.
journal, that you can't do that. But
No,
even if you own the journal, because let's say it's letters, and you were the recipient of letters,
Right.
so you physically, I mean, you have the physical letters, and you own them. If you paraphrase the letters, or you just use bits of the letters, but if you use the heart of the letters, the Nation case involved President Ford, and they used 300 words in a full-size book, and the Supreme Court said that wasn't fair use because it was the heart of the material.
Can I
So
just ask you
have to
right
be-
now?
It's not a slam dunk. Fair use won't help you necessarily.
And just
the
in
best
gen-
thing to do is get permission from whoever the literary estate
There were
owner
some
is.
cases in which I was covered by fair use.
Yeah, I'm sure. But in terms of letters, you have to be careful because a lot of people feel that if they own the letters, legitimately the letters were mailed to them by the person, then why can't they publish them? Because they own them. They don't own the content of the letters, they only own the physical letters. And I just had this come up 2 weeks ago. There was an author who wanted to get permission from Princeton Library to get access to letters, and he could get access, but they made him promise that he would use them without permission of the estate of the owner of the letters.
And Jen, because we're on fair use right now, can you please, because we have a varied audience, some people grew up believing that if you use less than 50 words from anything, that's fair use. Can you clarify for people, in fact, what is allowed for fair use?
There is no standard. What happens is fair use is now a statutory section 107 of the Copyright Act, and it's a defense to an infringement. There is no rule. You can't say it's 50 words, you can't say it's, anything. It's a case-by-case decision by a judge. The one rule of thumb that I think I could give you is based on a book that I read recently. Somebody did a very detailed analysis and decided that he would tell his clients, he was a lawyer, that if you use 1% or less of whatever you're doing, there's never been a case that's won that hasn't called that fair use. The problem is when you're talking about a poem or a song lyric or something that really has very few words, 1% could be, difficult to come with. But then you have the Nation case, which I said. The Nation article used 13% of the Nation article was this 300 words in the book, among other things. And the U.S. Supreme Court found that it was the qualitative importance of the quoted passages, and it was essentially the heart of the book, and therefore that they found it wasn't fair use, even though it was such a small percentage of what the total book was. I don't know what the total words are in a 300-page book.
I have two others, and it sounds like practical stuff, but it does affect everybody, especially some people are remotely. How does what you're talking about relate to social media?
It's exactly the same on social media as it is anywhere else. The law hasn't.
Broadcast, if somebody says something in an interview?
Well, again, if it's we're still talking actual malice.
Right.
And broadcast is slander on most
Is social
states,
media
definitely.
considered slander? The platforms
Well,
like
if it were on social media, Facebook, that would be libel because it's written out. And if it's tweeted, also libelous. I mean, if you said, you said, not a celebrity, but let's say you called a neighbor a whore or a prostitute, and you have followers on Twitter, you would be liable for that.
But the same thing in terms of excerpts or anything else. You're bound by the same rules as you would
You,
anywhere
for
else.
example, took, I can't remember the numbers now, but I know the Times, one of the Times articles about Trump's diatribes actually said how many times it said in his tweets. It had an incredible number, and that she really said, bad things.
Well, exactly.
But the thing is, who's
She
going to
decided
sue
do a
him?
book. Yeah, like with that, she did this. She did a collection of them in the book.
Right, but it becomes a question of who will sue.
Does
He is
But Trump will
suable.
sue.
Trump will
Yeah.
sue
Yeah.
because he has the money to sue, but
Right.
is Rosie O'Donnell, she probably has the money, but is she going to bother suing? I mean, that's the thing. You're dealing with an area that's so fraught with individual
Well, the Chilean
facts
official
and
saying, yeah.
situations.
And I
You want to make sure that you're not an easy target. In other words, they're going to go to a lawyer and they'll say, what are the chances I'm going to win this case? If I sue Hachette because they said that I'm only worth $5 billion and I think I'm worth $10 billion. The lawyer probably said, you got to be kidding, but if you want to pay me $2 million, then sure, I'll bring that lawsuit.
And I have one other question which relates to a very routine thing so many people have to face. An author gets a wonderful review in a newspaper. Can the publicity people take that review with the newspaper's logo and reproduce it on social media in publicity releases in hard copy without getting permission from the newspaper or magazine?
Probably not, and I think the newspaper or the magazine would probably say okay if they did that, but I would ask.
Yeah. We used to say if you wanted to use the whole thing,
Yeah.
you had to wait get permission.
I mean, you
Because
could
they
say
were
New
printed
York
by
Times
permission,
said
you
book
know.
was
Yeah.
fantastic.
No, we all
You
do
can
that.
all
No,
do
I'm talking about
that.
the use of the logo.
Sometimes
I'm
just
talking.
one word, impressive.
No, I'm talking about the
Yeah,
logo.
no, that's fine.
I'm talking about the logo, not saying that it came from the New York Times or New York Magazine. I'm talking about specifically using the logo.
You know, that's another issue. You know, let's say you wanted to write the history of monopoly, and it's a trademark issue.
Exactly.
And the people at whatever the game who made Monopoly,
As-
yeah, that's right. They're very, very
Litigious.
protective of their mark, and they're very litigious, and they have to do it in order to keep their trademark. And if there's any implication that it's confusing to the reader, and the reader thinks this is somehow sponsored by the manufacturer, then you could possibly lose that case. I know people have written about the history of Monopoly, and I don't know whether they got permission or not, but there is trademark risk if you do something like
Well,
that,
again-
especially if you use the New York Times.
Right, in that
and
logo
the
and
type.
font, in their font.
Right.
What's
If you
trademarked is
did
the
that
actual
with
font.
Monopoly, I think you'd have a problem. But if you just said, you know, the history of Monopoly is
That's,
is
using
seen
the
by-
word monopoly is not what's controlled, it's using that
And
logo.
if you use it in the context of the book as a, you know, an editorial thing, like, you know, I drank a Coke or, you know, this and that. But if you said, Coke is it as the title, using the color red and the same
Their logo,
print,
their trademark tag.
whatever it is,
That's it.
they will balk at that. And, you know, they may or may not sue you, but they'll give you a hard time.
Scrabble, we got a letter from
Yeah,
Scrabble.
Scrabble,
At
right.
Random House.
Cover that looks like a Scrabble board, and it's, you know, it's all two-letter words
Right.
for your Scrabble game. You know, you get a letter. I mean, I think they have someone who sends those out.
So-
I think they have to do it to protect their mark.
And
I'm
it's
not
trade
saying
dress.
that they would
Yeah,
sue
it's
you.
trade dress.
Right.
Yeah. At Random House, we were sued many years ago because our dictionary was too close to the red of Webster's. So it was a trade
Yeah.
dress issue, which was ridiculous, but never mind. Okay.
And titles can't be copyrighted, by the way. You can use the same title totally anytime
No.
you want to.
Yeah.
No, Harper Lee's lawyer did trademark To Kill a Mockingbird.
That's a trademark. It's not copyright.
Right.
Yeah.
Does that happen often?
No.
Yeah.
Because it costs money.
Yeah.
Well, you can.
I mean,
do
you
it.
can
I
brand.
mean, I trademarked when I published Susie Orman's first book.
Yeah.
Called We Learned It
Like the
Done.
Twilight
I
series.
It's a
trademarked
brand,
it
right.
because
Twilight
we were gonna
series
do a
is
whole-
very
yeah.
valuable. It's a
We were gonna
brand,
try
and if
do a whole
anybody
series
tries to
there.
use Twilight,
So there's a trademark on
Yeah.
that.
It's for
I would do
merchandising,
that.
right?
Yeah, for merchandising.
Yes.
And
Mine-
Harry Potter.
Yeah.
I'm sure she trademarked that because, you know, you have a series, you're in brand, there's
Sure.
merchandising, there's something to protect there.
Mhm.
But, you know, if you're just writing a random book and
Yeah.
you're not planning to make it into a series, I'm sure all the children's books, you know, like,
Well, the interesting thing is that movie titles you cannot duplicate. They're owned, and once you register a movie title, which happens when, when you're doing a book that you think might become a movie, you have to be careful about that because that registration protects it. Like I remember when I worked with Columbia Pictures on doing a book on Dracula from Francis Coppola. It turned out that for the longest time we didn't have a title for the movie because there was a big fight because Universal actually had the movie Dracula that they had done as a horror film. And so they had done a movie called Dracula. And Columbia couldn't get the release from Universal.
Mm.
So if you all look it up, the title of the Francis Coppola film is Bram Stoker's Dracula.
yeah.
There you go.
That's how they do it.
Interesting.
Yeah.
So I have a question. Rich, do we have any questions from our group outside? Okay.
I've been waiting, but I'm refreshing.
Very well. So I'm going to ask Dagmar her question first, but before I open the floor officially to questions, I'm going to ask our panelists if there's any points they have not had an opportunity to make that they'd like to share. and then I'm going to ask Dagmar to ask her question. But Boris, is there anything that you didn't get to that you'd like to make sure you share?
Well, not necessarily, because it's a little, I mean, it's a little off topic, but I did write an article about Harper Lee, who obviously is not somebody who wants to be written about. But in that case, I felt that I was on the side of trying to protect her, or at least ask questions about what was being done in her name. She had her copyright taken away from her. She has a lawyer that a lot of people suspect was not working in her interest. I was going to talk about her as a living person, but that changed. But in any case, I think, sometimes, there are reasons to write about living people that don't want to be written about, where you might feel like you're actually being their advocate. I mean, I remember somebody telling me that, in the absence of her being willing to talk, other people will speak for her, and no one will actually know what her interest is. And I think that was the sort of, nobody actually knows what happened toward the end of her life, but it was sort of a tragedy that she didn't sort of get to really say how she felt.
And you're talking now about the publication of Go Set a Watchman? Is that what you're addressing?
To be more specific, right? She, a lawyer who took over for her sister had been her lawyer. Her sister was a working lawyer until age 101, retired and died 3 years later. And this other woman sort of started taking care of it, took over for the firm, and then wound up making these very aggressive moves, trademarking it, which alienated her in the town that she lived in. And then when you really thought it wasn't going to get any worse, she published this book, which, again, there are two sides to that, but most people feel that it was probably not, she wasn't really capable of making that decision at that point, so, yeah.
Well, you felt you had to ask the questions they didn't want to have asked.
Right, and at that point, who was guarding her silence at that, so.
Bridget, I do have a question. Since you opened the channels to the Eleanor Barbara Clark, it looks like actually 3 questions.
Okay, can you hold 1 second? I'd like to ask Dagmar to ask her question, then I'm going to go to Barbara's question. Dagmar.
To return to the question of fiction again, when you open a book and you see a statement that says, this is a work of fiction, any resemblance of the characters herein with anyone living or dead is totally coincidental. And you read on, and you happen to know the setting, you happen to know that this is based on autobiographical stuff to some certain degree. And you're going on, and you say, oh, that's so-and-so. Oh, and you know damn well this is not a coincidence, that they are indeed reflections of what this person experienced and was a part of. Mm-hmm. Is that statement in and of itself protective of you, the writer?
It's one fact in a multitude of facts. You could point to it and say, but I told you up front that none of this is true. But if a person says, yes, but you went to high school with me, and I was in your class, and I sat next to you, and my last name began with the same letter that your character began with, and I always wore the same Yankee hat to class that you described as the person, then a trier of fact, whether it be a jury or a judge, is going to have a lot of facts, and then they're going to have this one statement, and they're going to have to make a decision. And you sitting around here, if you were the jury, some of you might say, well, yeah, but everybody who went to that high school at that point in time knows it was that person, and they're all going to believe that that person.
But it will have had to do damage to that person for it to take any action.
And the damage would be that you say he cheated on a test, and he was thrown out of, suspended, something like that.
Right, just that they're recognizable is not grounds for anything.
Right.
It has to somehow damage.
In the situation where this short story was, where this girl who won the contest at Mademoiselle, the damage was that she claimed people, she was called a slut, described as a slut, and that people wouldn't talk to her and were making fun of her, and that in the community, the small community where they both grew up, she was a pariah and she suffered damages. And she had to prove that, but it's not enough that it's fiction. It's not enough that you have your little disclaimer in it. What I think all the lawyers that you guys have dealt with in the past would say, change the sex, make it, from a male to female, disguise it, put it into a different country or a different part of the country, and make it so that it's not recognizable to somebody who was in that situation with you.
We have questions, Rich?
Yeah, I think this relates to that, and she said, there are actually 3 questions actually. Regarding disclosure to the public of embarrassing private facts, is truth a defense? I just said if she was a slut.
No, truth is, right, true. The issue in privacy cases is the standard isn't the same in terms of truth is a defense. If you say something true, let's say you say somebody's a homosexual 10 years ago when, it was damaging to your reputation. It's totally true, but you're outing somebody in a situation where it's going to cost them their job, it may cost them their marriage, it cost them their children's relationship. That's a private fact that is true, but it still has an adverse effect on them. And in the invasion of privacy context, truth is not a complete defense.
Right, okay. So what about photographs of people? She has a client who's writing a memoir, involves many living people and their embarrassing private lives. Does he have to get a release from still living non-public figures whom he photographed?
Well, you need a release from the copyright owner of the photograph, certainly, so that if somebody, if you know who the photographer is, that might not be difficult, but if you don't know, that could be very hard to do.
Photographer,
The photographer.
not the subject.
The subject, if it's an embarrassing situation, somebody without clothes on or something like that, there may be an invasion of privacy issue there, even though it's really their body, and there's no question of falsity. So it's not a slam dunk. It's like the Diana case. There was another case where there was a prominent person in a sanitarium, and she was a public figure, but the person she was on the tennis court with was just a private person who nobody knew was in this sanitarium. And the New York Post, it was Howell versus the New York Post. Ms. Howell was seen with the woman whose daughter was killed, and I can't remember it was very prominent. Anyway, she sued and she won because she expected to be in, and this person was in a tree with a camera, taking pictures, trespassing essentially.
Right.
But she had an expectation of privacy, and therefore she won. So it's, if you have a picture and you know the owner and you've gotten permission from the owner, you're probably okay unless there's something really awful. If it's just they don't look good that day, I wouldn't worry too much about it.
Right.
If they were seen with somebody other than their husband at the time where they were married to somebody else in compromising positions, that might be problematic because it's an invasion of privacy.
And then the last of this 3-part question. Is my client vulnerable to legal action? It's a good question. Is my client vulnerable to legal action from the heirs of a deceased public figure if he says negative things about that deceased public figure?
It depends on the state. New York, no. In other words, somebody's dead, but then somebody else wants to sue. In New York, I suppose if you use somebody's image in a commercial sense, then you could be sued for that.
And what state determines where this is?
It's the state where it's sued. That's the problem. If the person's in California, and I don't know every jurisdiction, I'd have to know 50 states. They don't pay me enough at the Authors Guild to do that. I could look it up. But for the most part, you're pretty free to say anything you want about somebody who's no longer there. But you have to really, most of what you guys say, and that is, you have to use it's not just the law, it's the moral and ethical issue. And you have to kind of follow your gut to know if you're saying something that's really going to get somebody's up in arms so badly that they're going to do anything in order to right the wrong.
Yeah.
And you both seem to be able to walk the fine line.
Yeah,
Well,
Bridget.
I've used the word negotiation before, and in one case, there were 3 parties. I wrote an essay about, it was called I Am Overruled, and I had to climb a mountain that was a destination wedding. It was like my idea of just, a nightmare. And the subtitle was something like, please excuse me from this destination wedding. But I had to go. So, I had to, so the one thing that the parties, 2 out of the 3, the groom and my son who went along, was that I referenced there was this little morning ladies sort of shower, and the lovely bride got a little pair of bikini underpants from her new sister-in-law that said in rhinestones, I do. So my son and these 2 31-year-old men were so embarrassed that I mentioned this, and the bride said, well, that didn't really bother me, so I just negotiated, kept it in, talked them out of it.
And it's in.
Stuck to my guns. So negotiation.
Write about people who love you, I think is what you're saying.
And Mary, you had a question?
Probably won't sue in any.
Yeah.
Mary had a question?
Just quickly, I always tell clients, get them to sign the release then. One of my colleagues had someone who'd done an Instagram project that was really great. She'd gotten no permissions. So suddenly she had to go back to people who at the time would go, great. But it's 3 months later, they're being ripped off. So always get your clearance as soon as you're there, before someone tells them they're being ripped off. But the question I wanted to ask is something that confuses me as an agent, is publishers' insurance. You only hear about it when you question something in the warranty clause and they go, if we change a comma, you're not covered. So you go, okay, well, we want to be covered. And then I go, well, what's the coverage? And they don't. Well, all I know is that usually there's a limit, an aggregate limit, so that let's say HarperCollins has a season of being sued. If you're sued later, you have no insurance.
No, it doesn't go that way. I used to be the person who...
Good. Well, I just picked HarperCollins.
I was the risk
arbitrarily.
manager in News Corporation, and
But I'm
HarperCollins
saying,
is our
how
subsidiary.
exactly does publisher's liability insurance, where does it begin or end? Is there any general, I know
I'll tell
the
you.
5 publishers that are left, they might each have a different
And I'm not
bar.
sure, I don't know how many of the smaller publishers have the insurance, but
honestly,
let's say the 5 publishers, they have an media liability insurance policy.
Right.
They negotiate it every year depending on how many lawsuits are filed, how much they have to pay out, etc. They have a deductible which can be as large as 6 figures, as I said, in HarperCollins it is. So that means even if they win, if somebody sues, it's going to eat up a lot of money through summary judgment, getting rid of it. You're pretty much going to pay $100,000 just to go through that process. And usually, it's even if you don't put it in the contract, if you are an author of HarperCollins or one of the other publishers, you are automatically listed as an insured for purposes of HarperCollins insurance. But if you are sued without HarperCollins, in many cases their contracts say you have to pay the entire deductible, not just a percentage of the deductible as the contracts say. Most contracts say, and you want to put after final adjudication. You don't want to just say, because anybody can bring a lawsuit, it can be expensive, you're totally found, off the hook, but you're still subject to paying part of the deductible. And if HarperCollins isn't sued, although 90% of the time, 99% of the time, you're going to want the deep pocket in there, so they're going to sue. But Maxwell would always sue the author alone. And the repercussions of that, and Trump would do that too, because he doesn't really care. He wants to go after the the little guy to stop him and stop everybody like him.
And bully him,
And he's
and
a
scare
bully.
him, and scare him.
But that's 1%. So there's money there for everybody during that year. And it's just a question of whether their premiums go up the next year in terms of how many payouts they have. There's no cap.
And Pat, you had a question, Patricia?
Yeah, I had two questions. Issues that I used to deal with when I worked for a publisher, editorial issues. And since I've been freelance a number of years, I wonder if the landscape legally has changed. One area is satire, humor, and there used to be broad First Amendment protections for satire in almost all forms, whether
You know,
it's
it's
a
funny.
novel,
It's funny you say that. It's not satire. It's parody.
parody.
And there's a difference between them.
There is.
And the Campbell versus Acuff Rose case, I think it was 1994, the Supreme Court said that this was a transformative use of Pretty Woman, Ugly Woman. It's a song that was a parody in that song, but they made it into a different animal, different song, and therefore is a parody, and it was transformative, and you can do that, and that's fair use. But they made a distinction between satire and parody, because satire, you're not really changing it. You are looking at it in the context of an environment or a story, and it's not the same thing. But parody, if you parody something, you're like the Dr. Seuss books. I remember they came out with a book that was a parody of Dr. Seuss, and it rhymed, and I can't remember what the topic was, but they had every right to do that because it was a parody.
But what about satire? There are protections aside from First Amendment?
They really, if you read the Campbell case, it basically says it's not protected because it's not a parody and it's not transformative.
Interesting.
It would depend on what you're doing with it,
Right.
you know.
The other issue that came up would be in memoir, and I do work with quite a few clients who are writing memoirs, and they might be writing something about abuse that took place in a family. In other words, they have a very particular point of view that might be theirs alone. And if they're in a negative relationship with other family members, or they're not in a position, they don't feel comfortable showing it to the people being described, and these people are still alive. I realize it's a completely different situation if they're not alive. What kind of protection is there in stating, this is my point of view, you know, as you would with a fiction disclaimer, there might be others, but this is my story, my
That's
version of
opinion.
events.
And that's your opinion. If you make it your opinion and you have objective facts which lead to your opinion,
Right.
then you're okay.
Right.
But if you say something as if it were a fact, you know, that this person, you know, I don't care what anybody says, this person, you know, is a crook, and I know that this person's a crook, then that's defamatory. But if you say, you know, it was here yesterday, and the only people in the room were these two people, so one of them must have taken it, and I don't have any knowledge specifically of what it was, but in my opinion, you know, if you couch it in opinion, then chances are you'll be okay.
Yeah, and I figure most good writers know that they're to keep records, that they do, if they do wind up getting sued and have to have a hearing in a court of law, they'd have to show some evidence of how they came to this position. Right. They'd have to have it be a reasonable conclusion rather than something wildly.
Well, that would go to reckless disregard of whether it was true or not. You
Right.
could show that, you know, I was taking this into account when I made that statement.
Right. Okay.
And even though it might not have been an accurate statement, I had enough facts to make it not actual malice.
Got it. Okay. It's a
Now
little bit
I-
subtle, but it's
I-
an interesting thing that comes up a lot when people are writing about abuse, for instance.
Of course.
Or persecution of some kind, or a traumatic incident that happened to them. That's why a lot of people write about these things. So it can be tricky. Thank you. I appreciate it.
Well, I want to thank everybody for being here today, certainly everybody who's in the room and participating, but most of all, our panelists, to Boris, to Eleanor, and to Jan. And I want to let you all know that on May 4th, we're going to have our next event, and you guys get to vote on what you'd like it to be. So everybody, including our panelists, get to tell us what you'd like to talk about at our next event. We do them every other month. But most of all, I want to say thank you for being with us, and thanks for this incredible conversation.
Thank you.
Thank you. Thank you.